I'd like to call to order the City of Davenport Plan and Zone Commission meeting today, April 3rd. It appears as though we do not have any public hearing agenda tonight, so we will move on to our regular meeting. Roll call, please.
Connell is excused. Hepner.
Here.
Ingram.
Present.
Kelling.
Here.
Lammers.
Present.
Manus is excused. Martinez. Med.
Here.
Quinn. Reinhartz.
Here.
Tallman here. We have a quorum, Mr. Chairman.
Thank you. Report of City Council activity. Thank you. Secretary's report.
Second.
All in favor? Aye.
Aye.
Opposed? None. Report of the Comprehensive Plan Committee.
Hi, Matt Flynn, Community Planning and Economic Development Department. Recall our last meeting, we had a pretty extensive discussion about two items on the action agenda for today, the comp plan amendment for Elmore Corners, and then eventually we'll be talking about the design guidelines. I don't have don't let the PowerPoint scare you. There's only about a couple slides I wanted to hit. So again, we think it's important that the work that's gone into the Elmore Corners plan actually be memorialized and find its place as part of the package of comprehensive plan documents. So yep, so a couple slides out of order there. This kind of provides both or kind of restates the findings and why we think it's important to do this. And the main reason is that zoning without policy behind it is subject to challenges. We think that the process has been a good one. There's been extensive public input solicited and received, and we recommend adoption of the plan. Any comments?
Commissioners, any questions, comments? Seeing none. Thank you, Matt. Even though we historically did not allow conversation from the audience on our meeting night, our regular meeting night where we vote, we've changed that policy a little. So if anybody would like to step up and speak in favor or opposition to this case CP 18-01, please do so. You can have a couple minutes. Please identify yourself.
Thank you. My name is Candy Pasternak. I'm with Pasternak Law Firm. It's my understanding you members have all received a letter from our office authored by Mr. Jaeger. And at this point in time, I appreciate the opportunity to speak and the change in the rules. Our concern is that with respect to Davenport Commons that has already been developed, and as set forth in the letter from Mr. Jaeger, THF Davenport spent a good deal and invested a good deal of funds in developing that property and recently has expanded that development with golf. I think it's Golf Galaxy at Dick's and the Field and Stream and all of that that's going on, to the point that this proposed Elmore Corners plan would encompass the schematic or the geographic area that's covered by this plan extends to the south border of the property that's already occupied by the Davenport Commons development. There are pockets of vacant parcels within the Davenport Commons development that are still available for development by THF North, and there are plans to do so. But if this comprehensive plan overlay extends south to the very southern borders of Davenport Commons, then there are going to be new restrictions and in essence, in the line of some of the cases, the Supreme Court case of Dolan versus Tygard, and then our own Iowa Supreme Court cases of Stone versus City of Wilton and Newsel versus City of Iowa City, summarizing, it's basically a taking by a more restrictive zoning that currently exists for the property that's previously been developed, so that anyone trying to come in, if the Elmore Corners plan extends south and includes all of Davenport Commons, you will have property that exists there. Saying it another way, if they were trying to come in now to put that development, I don't think it would meet the requirements, the design requirements that are in the Corners plan. So now you're going to have this area, which, if my geography is correct, is the area south of 59th that runs east and west there. I think it's 59th. It's almost fully developed. There are just pockets of, okay. I don't know how to work. I'm technically inept. There, oh.
Use that as a pointer.
Okay. Well, he just had, oops, well, I'm doing really good. Okay. There's, I don't know how to work the pointer, but just north, if I might. I'll do it old-fashioned way. Okay, the development, the area I'm talking about is this right here. You know, this is where the Walmart and, oh, thanks, Wayne.
If you could, though, could you come back, so we're
Yeah.
recording this, we'd like to have it on the microphone.
So I'm just talking about the area, this area that's
Up on the
already
microphone,
basically
please.
developed. Okay. That area that's already basically developed, and there's just pockets of property that's left vacant but is available for developing. Right now, I believe there's a tire store right there. So with the design guidelines and the overlay, there would be a requirement that there be windows along the Elmore frontage there. So if you have a tire facility there and it's all windows on the frontage, guess what everybody gets to see when they're driving down Elmore at that location? And that's not a fair restriction on an existing use. And so our concern is, and we don't fault anybody for having a plan to try to develop a comprehensive design, scheme and schedule, but, the area that would be most conducive to that is that's already completely vacant, that you're not going to affect existing uses or challenge further development in the property. So you'll have inconsistent looks and uses or restrictions on those uses, which obviously will affect marketability, which then leads to my argument about the taking issue.
Commissioner Tallman has a clarification question I think he'd like to ask of staff.
Thank you, Mr. Chairman. Man, on page 8, I don't know if these pages line up, but where the site layout plan, map 3, again on page 8 of the study.
I'm going to have to open it. Hang on.
Yep.
Okay.
Is this showing the boundaries of the of what Elmore Corners is going to be, or where all these new site and structure requirements would fall into place? Because if it is, it looks like it only impacts one lot within the property that we're discussing. Is that correct?
Yeah, that was an excellent catch. To be honest, why the map showed the balance of what is now largely the developed property, I really can't tell you. I think the points that Ms. Pasternak is making, it's good. Obviously, if the existing development was to redevelop, we'd be looking to apply those standards.
And then we could amend that, correct?
Pardon me?
We could always amend.
You could, or you could. I guess I'm saying I'm open. You could. I don't see a major issue with leaving what is on the attachment move forward. But I totally agree with you. What's being shown is just that small out parcel out front.
I guess moving forward to where we are today, I mean, if that was even eliminated, if that was just taken out, so it doesn't impact the commons,
I think you've got. I mean, we just received the notification yesterday, so feel a little uncomfortable making a specific recommendation. But I think your options are, if you are looking to move the plan forward to council, would be either to include the development as shown there, the small development that I think you were pointing out, Commissioner Tallman, or to not include any property on the west side of Elmore, south of Pedcor, right, or Cross Creek Apartments.
well, your concerns aren't to the west there, are that your concerns?
We're east and south, so east of Elmore,
Just so you,
between Elmore and 74.
if there's a way to show you what we're talking about, because it's not on that, if you,
Okay. Sorry.
what'd you say our options are then, man? I'm sorry. Moving forward.
I think one is to move forward as that map shows. I can't specifically give you a reason why that map was prepared. I prepared that map, but why that's different from what's shown obviously in the plan by just applying to that, I'll say those outlots, or remove that altogether.
I guess I would like, if you need a motion to change this map 3 site layout plan to eliminate just that one parcel on the east side of Elmore, south of the Pedcourt of Elmore. If that's 59th, then so be it. Or basically what's shown in the commons.
Okay. If I could clarify again, we're talking about the plan right now, and I think what the concerns are is what any ordinance would apply to, which would be the exhibit that's shown up there. It's a little bit of out of order. I think the motion that you're suggesting
Comes later.
would be as part of the ordinance.
Under our zoning activity.
Yeah.
Okay, I will.
Might I ask a question?
You can ask the chair.
Okay. On this page 8 that we've been discussing now that you, Mr. Med, kindly provided to me, it appears that the Davenport Commons is not included, although on the Elmore Corners Overlay District that's reflected on the diagram that's on the screen right now, it is included. So is there something later in the documentation that takes Davenport Commons out?
That's what we're discussing right now, but we're not going to do it in this part. We've got another piece coming up where we'll entertain that motion.
Oh, okay.
Again, I will. As far as our participation in this process, we really kind of caught this in midstream. When we did the notifications for the public meeting, we assumed that we went 200 feet beyond the boundary shown up there. But as we go through the plan document, it really just addresses those two L-shaped buildings that are out front. And again, I'll say the question as far as it relates to the existing development, whether or not it should apply to that or not. I will say, if you can look further, you can look at the Cross Creek development that is also shaded out, as well as the self-storage units. Mill Chevrolet is not indicated as part of that as well. But I think the only concern would be is in the event of a major redevelopment, given the age of the structures there, not very likely, at least in the short term. The chances are of these design guidelines being applied in impacting the existing development there pretty low.
Thank you, Matt.
Thank you.
Thank you. Any additional questions of commissioners? Seeing none, roll call, please.
Hepner,
Yes.
Kelling,
Yes.
Lammers,
Present. Yes.
don't do that to me. Med,
Yes.
Reinhardt,
Yes.
Tallman, yes. Motion carries.
We will now move on to zoning activity. Commissioner Lammers.
All right. We have two cases tonight. Case number ORD 18-01. Under new business. We have none for old business. Amendment to Title 17.41 of the Davenport Municipal Code, creating an Elmore Corners Overlay District, ECOD, and design standards, 6th Ward. Staff recommends the Plan and Zoning Commission forward case ORD 18-01 to the City Council for approval, and I so move.
Case number ORD 18-01's been moved and seconded for comments and discussion. Matt?
Again, the ordinance is actually, the teeth of what we're referring to. We were proposing to use an exhibit to show the area affected rather than try to assemble meets and bounds and other legal descriptions to create a real monster here. So, again, I wanted to touch briefly. Commissioner Hepner had made some comments that made their way in the latest draft. First of all, the removing of the requirement for rectangular buildings, that's out of there. I also, to respond better to the concern about quality, if you go down the ordinance in that subsection 3, gets a little bit more specific on how that's addressed. Use of concrete, that language was altered, I think, to allow for, I'll say, the creative use of traditional concrete products and finishing, and making a clarification when it comes to metal buildings that we're talking about allowing and encouraging architectural metal type products, not the traditional, I'll say the old school pole building type questions. And for Commissioner Reinhardt's had some questions posed separately about how buffering was going to be applied. We've had some discussions really throughout the day on that, and I think the concerns were, provisions that were included in even subdivision documents before we're now considering this. Do they still apply? Yes. Does the plan help maybe shape those requirements further? Yes. Do we really know how those requirements are going to be applied when we don't have development and site plans involved? We really don't, but I won't speak for him, but I think some of his concerns have been alleviated on that. And then finally, I would say at this point, if you wanted, I would not object to removing the THF development from the area, in essence, the overlay district at this point. The more I look at it, it doesn't seem that was intended to be applied there.
Thank you, Matt. Yep. Commissioners, questions? Commissioner Med.
Thank you. Matt, that little hookout with the 2L buildings, is that property owned by THF now? Do you know?
I believe that whole area is.
Okay.
I don't know if it's leased to somebody else right now, but
All right.
I
And
believe it is.
this is, I think I heard about the discount tire situation, but if this overlay had been in place when THF was doing their development, would we see a major difference on what we're
Yeah.
looking there? Would we?
I think you would. You would have seen development brought much closer to the street. Maybe you would have seen the fields of parking reduced to smaller clusters of parking. I can't say that the character of development would not have changed if we were working under the proposed set of standards.
Okay.
Could those uses be accommodated on that site with the new requirements? Yeah.
Okay. And another probably abstract question, but it's possible with the property remaining that THF would benefit from better design depending on what gets put on that property, right? I mean, that's kind of a long shot, but
I
that's
would.
the idea of this whole
Yeah,
design
and
plan.
I maybe touched on this previously, but generally, it's been my experience that, when governments propose, well, in this case, new, more stringent zoning requirements onto a larger area, a lot of times they're often not, rejected unilaterally because developers see that it's a way to maintain a high level, so I can be assured that I may be the first to develop in this area. I'm not going to be impacted by somebody, and I want to develop a high quality, top tier retail development. I don't have to worry about the next person in just doing something, I'll say, more schlocky.
Is that a legal
Say that?
term? No. Okay. Thank you.
Commissioner Tallman.
Thank you, Mr. Chairman. I'd like to make a motion to eliminate the parcel east of Elmore that in the THF Commons property from the overlay district.
I'll second that.
And that includes the L-shaped,
Yes.
2 L-shaped.
Yep. Yeah, that's what I'm referring to. Yes.
That motion's been made and seconded. We're just going to do a quick vote on that. All in favor signify by aye.
Aye.
Opposed? Five in favor, one opposed. Any additional conversation? Anybody from the audience like to speak? Any commissioners have any more questions? Roll call, please.
Kelling,
Yes.
Lammers,
Yes.
Med,
Yes.
Reinhardt,
No.
Tallman, yes. Hepner.
Yes.
The main motion carries.
The second case, case number ORD 18-03, request of the City of Davenport to amend Title 17 of the Davenport Municipal Code entitled Zoning by amending Section 17.36.030.B.6 by adding sale and storage of fireworks and explosive devices, subject to such uses being located more than 1,000 feet from any residential district to the list of permitted uses in the M1 Light Industrial District. Wards all. Staff recommends the Plan and Zoning Commission forward case ORD 18-03 to the City Council with a recommendation for approval, and I so move.
Case number ORD 18-03 has been moved and seconded for discussion. Ryan.
Thank you, Mr. Chair. Ryan Rusnak, Community Planning Economic Development Department. Since the public hearing, city staff discussed the proposed amendment and decided to go in a less restrictive manner. We still are proposing that the sale of fireworks be located in an M1 district as opposed to an M2 district. However, we retain the 1,000-foot separation distance to residential districts. No longer would it be a special use permit, but essentially this would be a permitted use with conditions. As we discussed more internally, felt that the M2 with special use permit was pretty restrictive and very limiting, and so we didn't want to be in the direction of that limited. So M1 as permitted by right with the separation distance of 1,000 feet to residential. And that's our recommendation, Mr. Chair.
Thank you. Commissioners, have any questions? Anybody in the audience like to speak?
Thank you, Mr. Chairman. Commissioners, my name is Brett Marshall. I'm an attorney with Lane and Waterman here in Davenport. We represent a property owner in Davenport, Jake's Fireworks. And Jake's Fireworks purchased some property in reliance on the city's current ordinances, which allows for the sale of fireworks within a C2 district, for example. And what the city is now proposing to do is essentially take away that right and the reliance rights that my client has used in purchasing this property, to take that right away. A significant amount of planning has gone into this. The application has been submitted to the state for the consumer seller's permit to sell the fireworks, and so we would object to this change at this time. As staff knows, in order to obtain a state license, there has to be a significant amount of safety measures incorporated into the site plan. There has to be inspections to determine whether the site is safe to sell and to store these fireworks. And so I'm a little bit confused as to why the city would now deem it necessary to limit the sale of fireworks with all these current safety measures in place to an M1 and restrict it to an M1 district. So, thank you.
Thank you. Would staff like to comment?
I do recall conversations previous to this proposed amendment about retail sales of fireworks. It may have included this client, and certainly that information was correct when it was provided. There has been a building permit submitted, as I'm aware of. I'm not aware of when the property was transferred or when the state application was submitted. I think we're going to have to confer with legal to see if and when there was any, what we call a vested right, essentially allowing them to proceed in the face of an ordinance change. But we do recognize that there has been a complaint lodged with the proposed ordinance. I think we're essentially going to have to talk with legal and their attorney to see where they are in the process and since when we commenced the amendment.
Thank you, but sit tight for a second. Commissioner Tallman?
Thank you, Mr. Chairman. Ryan? I know you didn't. Just a question. If you guys are going to have these discussions with legals, is there any problem tabling this for a cycle or two, or is there a rush on this for any reason?
Well, this is a timing issue. I don't think I don't know. I think there's a timing issue with getting the ordinance passed before other retailers come into Davenport and set up shop. And so with an ordinance change, we need to get 3 readings through City Council. And so from that standpoint, any delay gets us closer to that July time period where sales could occur.
So it's possible if we were to move this forward with whatever vote between now and the first reading at council, you would have had the opportunity, or legals would have had the opportunity to talk.
I think with the opportunity for 3 readings through City Council, there's still plenty of time for public input.
Thank you.
Thank you, Ryan. Commissioner Lammers?
In follow through with Commissioner Tallman's question, if there's an extensive process by which to get licensed to sell fireworks, etc., why would all the other people that are coming in that you spoke to not have to go through that process, which would take time, which would afford the tabling of this discussion for us to be able to get the information we need to make the right decision?
I think anyone that comes in and tries to set up for the retail sales of fireworks, there's going to be some process involved with state licensing and local permitting through the fire department. I don't know where anybody else is on that, in that process. I have no idea. I think it just came to light this week that this person had purchased this property and we're setting up for this. I don't know where anyone else is in the process.
Thank you.
Any additional questions? Commissioner Kelling.
Thank you, Mr. Chairman. This is probably a stupid question, but is there any consideration under the interpretation of the word sale between a distribution location as opposed to a retail distribution? In other words, the way when I read this, this all sounds all right. We would have a distribution center, which is kind of like a sales center in an M1 district. I didn't think we were talking about or dealing with a retail out on 53rd and whatever 2 weeks before the holiday. I mean, am I wrong in that, trying to differentiate between what is a sale as opposed to distribution?
There is no differentiation.
There isn't.
Correct.
Should there be?
The city's opinion is no. I mean, when you initially looked at the M2 classification of what required a special use permit, it discussed certain intense uses that included explosives. And so the potential for an explosive material to be stored on site, whether that be in large quantities or smaller scales, there's still the potential of being explosive. And I think the city's opinion is you want to limit those to certain areas of the city and have a separation distance to residential, whether that be for distribution or retail sales.
So if I'm understanding, then the objection that the representative from Lane and Waterman has just raised, we would be foreclosing any future retail sales in various locations?
Yes. Well, they are by nature now. Obviously, you've got to have a commercial location,
Yeah.
right? It would just restrict it to certain more intense classifications. If you had
Which would have to be quite far removed, obviously, from residential areas.
Sure. Yeah, 1,000 feet.
Yeah. Is there a motion at this point to table this?
No.
No. I'd like to make a motion that we table it for one cycle so we can maybe think through this a little bit more.
It's been moved and seconded to table this petition for one cycle. Roll call, please.
Lammers,
Yes.
Med,
No.
Reinhardt,
No.
Tallman, no. Hepner
No.
and Kelling.
Yes.
Two to three, the motion fails.
That being said, we'll move along with more questions. Commissioner Reinhardt?
Yeah, I had one question. Is this ordinance designed for brick and mortar or both brick and mortar and tent locations?
It would apply to both.
All right, thank you.
Any additional questions? Commissioner Med?
Thank you. What other remedies would this property owner, I forget his name, have? I mean, it seems like we've got him caught in the middle. Can he come in and ask for a zoning change to the piece of property he's already purchased, or are we just leaving him out to to dry here.
I think there's two options, and I think this is where the discussions with their attorney and city legal staff is if there is any vesting based on where they are in the process, based on when the process for the ordinance change began. And so there's perhaps the potential that it could be located in the current district because that is what the current law is now. And the other option, which is I would say more challenging, would be to rezone to an industrial in an area that doesn't really have an industrial zoning.
Okay.
I think the latter would be very challenging.
Okay. Thank you.
Any additional questions? Seeing none, roll call, please.
Again, this is for the main motion. Med,
Yes.
Reinhardt,
Yes.
Tallman, yes. Hepner,
Yes.
Kelling,
No.
Lammers.
No.
3-2, the main motion carries.
That concludes the zoning activity.
Thank you, Commissioner Lammers. Commissioner Hepner will move on to subdivision.
Thank you, Mr. Chairman. There are one case for the commission today, case number F 18-2, final plat of Bettendorf's, or Betts Corporation, second edition on 7.40 acres, more or less located abutting to the east of 741 West 53rd Street, between 53rd Street and Colony Drive, containing 3 lots. The property is zoned R1, Low Density Dwelling District. Staff recommends the City Plan and Zoning Commission accept the finding and forward case number F 18-2 to the City Council for approval, subject to one listed condition, and I so move.
Case number F 18-02 has been moved and seconded for discussion. Wayne?
Since we've only taken 35 minutes, I have about 40 slides for you. No, this is a case you had 2 cycles ago where it was a 1-lot subdivision. They did submit actually now a 3-lot subdivision. Basically, this area again does meet our zoning and comprehensive plan requirements. This is the plat, the 1 lot here, which would be attached to this lot, and that's what's driving the subdivision. This second lot located here, and then an outlot down here, which will either be tied to lot 2 or will be offered to the adjoining property owners if they want to buy it as a buffer type of situation. So it's pretty straightforward, does conform, and we would recommend approval. The plat is just missing a north arrow.
Thank you, Wayne. Any additional questions or any questions from the commission? Seeing none, roll call, please. Thank you, Wayne.
Reinhardt,
Yes.
Tallman, yes. Hepner,
Yes.
Kelling,
Yes.
Lammers,
Yes.
and Med.
Yes.
The motion carries.
That's all I have tonight,
Thank you.
Mr. Chairman.
We do have a little hiccup that we need to back up on. Case number CP-1801, Matt from the comp plan. We never had a motion or a second on staff's recommendation on that. We went ahead and went into the vote, but we never.
Want to do a redo then?
Well, I think we should fill in the gaps. It'll be the very first one, CP-18-01. After Matt made the presentation on Elmore Corners, the comprehensive plan piece. Would anybody like to make a motion?
I'll make the motion.
Do I have a second? Been moved and seconded. I think we should go ahead and just take a revote on that. If you all remember the case from 15, 20 minutes ago, CP 18-01. Roll call, please.
Hepner,
Yes.
Kelling,
Yes.
Lammers, Med,
Yes.
Reinhardt.
I'm going to change my vote to yes.
You're not.
I can't?
No, you're not changing your vote. You were yes before. Right?
Oh, I was.
This is for the comp plan. This is
Comp
not,
plan,
this
not
wasn't
the-
for the zoning. And, Tallman, yes. The motion carries.
Thank you.
All right.
I'm
Thank
sure
you.
that was.
It appears as though at this point we do not have any future business.
Move to adjourn.
Nobody's perfect.
Hold on, we're not there yet. Do we have any communications from staff or anybody in the audience? Seeing none? Any additional business? Seeing none?
Move to adjourn, Mr. Chairman.
All those in favor signify by aye. Opposed? We are adjourned. Please drive home safely.
I'm not going to jail for that.
I bet you're not.
I don't look good in jumpsuits.
No.